All rise. Vaya Bulave.
Please be seated. May I ask you to continue? Ms. Bake.
Thank you, Your Honors. Before I begin, I have two small housekeeping matters. First of all, we're joined by our colleague Abir Hassan at the prosecution table. And second, I've been asked to make a correction in relation to ground 29 that Ms. Gustafson spoke about this morning, or this afternoon. She referred to Perlich Appeals Judgment paragraphs 584 to 591, and the correct reference is to Perlich Appeals Judgment paragraph 3022. So I was speaking about the false premise that everything in this judgment was based on the single intercept. And I was taking Your Honors to what Karadžić was doing to oversee and ensure the success of the operation. And the first, I was going to give you three categories. The first category was using numerous channels to monitor his forces. And I spoke about the written reports. But Karadžić also received information orally directly from high-level officials, from the military, the police, and the civilian authorities. For example, on the 13th of July, as the organized killings were beginning, from the VRS, the military, Karadžić spoke directly with Mladić, who was the commander of the main staff, in the evening of the 13th of July for more than 1 hour. And shortly after that conversation, Mladić ordered his forces to move the prisoners to Zvornik to be killed. That's paragraph 5711 and 5818. From the police, Karadžić met personally with the Minister of the Interior and the police commander, Kovač, on the afternoon of the 13th of July. And Kovač briefed Karadžić on developments in Srebrenica, including all the information that he had obtained from the state security and police subordinates. And immediately thereafter, Kovač went to the Srebrenica area, met with Mladić, and then toured Srebrenica, Bratunac, and Zvornik, where he observed the transportation of the men to Zvornik and spoke with leading participants in the killings. And when he returned the next day, he briefed Karadžić immediately upon his return about the progress of the killing plan, paragraphs 5781 and 5782 of the trial judgment. And as we see from the 13th of July intercept, Karadžić also spoke to Deranic, the top civilian leader in Srebrenica, on the 13th of July. And by this time, the chamber concluded that Karadžić already knew that there was a plan to kill the prisoners, 5811. But, Your Honors, it wasn't just high-level officials. Karadžić also received information from those much farther down the chain of command in the VRS and the police, and from civilians. For example, the trial chamber found that on the 14th of July, he received a phone call directly from a field commander who was defending the major road north of Srebrenica, and that field commander reported directly on the progress of the column of the Bosnian Muslim men in the woods. And the same day, Karadžić met personally with a group of civilian authorities from Serb Srebrenica, and their discussion included the creation of a war presidency. And on 15th of July, he received a direct report from Vasic, who was the Zvornik police chief. And Zvornik reported that additional forces were urgently needed to help to intercept the column of men, and additional forces were sent the next day. And when Karadžić wanted more information, he got it. Karadžić summoned Bajagić, who was a low-level VRS official, to his office in the middle of the night, around 1 a.m. on the 15th of July, to report on the events in Srebrenica. And Karadžić would send his trusted subordinates to gather information in the field, as he did at the beginning of the operation on the 13th of July, when he sent Kovac to tour the crime sites, and as he did on the 16th of July, only 90 minutes after the VRS had opened the corridor, when he sent Karsik to Zvornik. The trial chamber concluded that Karadžić closely monitored the operation, and despite his power to do so, despite being the only one who could have done so, Karadžić did nothing to halt or hinder the plan. The chamber concluded that this furthered the plan's objective, paragraphs 5829 and 5830. Turning to the second category of Karadžić's oversight and involvement. This involved giving orders ensuring the success of the killing operation, including by appointing key subordinates. So in addition to the intercepted conversation, the intercepted instruction to Derenic, which I'll return to in a moment, Your Honors, on the 13th of July, Karadžić promoted Krstić to command the Drina Corps. This is Krstić, whose brigade in 1992 had separated men from women and then committed an organized massacre of the men in Sokolac's municipality. Krstić, who personally supervised the separations and forcible transfers at Srebrenica, and Karadžić rewarded him with a promotion, and later heralded Krstić as one of the main architects of the brilliant victory in Srebrenica. And I would refer you to paragraphs 1047, 1062 to 1063, 5813, and footnote 19768 of the trial judgment. And in the 6th of August assembly, Karadžić lamented that had Krstić not been sent elsewhere, he could have ensured the column was encircled and destroyed because he had, quote, proven to be very good, end quote. That's exhibit P1412 at page 17. And another order on the 14th of July. Karadžić, with full knowledge of the ongoing killing operation, Karadžić declared a state of war in Srebrenica, paragraph 5819. On the same day, he issued another order appointing trusted Derenic to the position of president of the war presidency. The chamber found that there was no longer a military reason for such orders. Instead, these orders were issued in order to facilitate the, quote, smooth execution, end quote, of the killing operation, paragraph 5819. And his orders gave the military and Derenic extraordinary powers to commandeer civilian personnel and resources, such as excavators, that were required for the large-scale killing and burial operation. And these additional powers were critical. After the mass killings at Kravica warehouse on the 13th of July, the main staff scrambled through the night to find the heavy machinery needed to bury the bodies. And the additional powers granted by Karadžić enabled his forces to accomplish the Herculean task of burying more than 5,000 dead bodies in just a few days. Karadžić claimed the defense claimed this morning that the effect of the declaration of war was limited to Srebrenica. But that's not so. Paragraph 3, which was what was relied on by the chamber in footnote 19627, explicitly covers the armed forces throughout the area of responsibility of the Drina Corps, which includes the municipalities of Srebrenica, Bratunac, and Zvornik, paragraph 190 of the trial judgment. And the third category. Karadžić's involvement is further illustrated by the steps he took to shield the killing operation from international attention and international intervention. It was Karadžić who personally controlled access to the area, and he used his powers to prevent internationals from accessing the area while the killing operation was ongoing. He ignored UN demands for access to the Srebrenica missing in July and August. It was not until late July, after the murders were done, that the ICRC was granted restricted access to the area. They found only 164 detainees from Srebrenica, and they were told that there were no more. And we can see from prosecution exhibit P5177 that various UN bodies were still seeking access to the missing or dead on the 30th of August, 1995. And I would refer your honors to paragraphs 5787 and 5788 of the trial judgment. Karadžić also disseminated false information about the fate of the Bosnian Muslim men. He deliberately lied to David Frost of CNN on the 17th of July, giving answers that suggested that the missing men and boys were still alive. And in order to avoid unwanted international scrutiny, Karadžić allowed the Bosnian Muslim local staff of UNPROFOR to leave with the UN. Murdering them would have attracted too much international attention. Paragraph 5132. Karadžić also knew about the massive reburial operation conducted by his forces in September and October 1995. And you'll recall that during the dead of night, they moved bodies from their original mass graves into multiple secondary ones to conceal the evidence of their crimes. This ghastly operation was triggered by the international community's discovery of the existence of mass graves when the US Secretary of State Madeleine Albright addressed the UN Security Council in August 1995. And following Albright's visit to one of the suspected execution sites in March 1996, Karadžić and Mladić celebrated in the success of their cover-up. Karadžić boasted that, quote, "A big show was put on for Albright. She expected they would find 1,200 Muslim bodies, but they found some 5. Paragraph 5793. Your Honors, this is why we say that Karadžić's argument is based on a false premise. It's clear that the Chamber's assessment of Karadžić's intent and involvement in the JCE goes far beyond the single intercept highlighted by the defense. There are layers of evidence and findings against him that prove his shared intent and involvement. I'll now turn to Karadžić's challenge to the intercept itself. That is not the correct slide. No, it's this one. In an intercepted conversation that you've already heard about, a call at 8:10 p.m. on the 13th of July, 1995, Karadžić asks through his intermediary about the prisoners in Bosnian Serb custody. Darinić
We are ready now.
So Karadžić asks through his intermediary about the prisoners in Bosnian Serb custody. And Darinić informs him about the large number of detainees in Bratunac, some 2,000 with more expected overnight. Derenich's information in this intercept is consistent with the Chamber's findings that on the 13th of July, between 1,500 and 2,000 Bosnian Muslims were already detained by the Bosnian Serb forces. That's paragraph 5707. And then Karadžić gives an instruction that all the goods must be placed inside the warehouses before 12 tomorrow, and clarified that he meant not in the warehouses over there, but somewhere else. Your Honors, Karadžić acknowledges that this call took place. He admits that Derenić was informing him of the large number of detainees in Bratunac. He says they were using code, that by goods he meant Bosnian Muslim prisoners. References are at footnote 18019 of the trial judgment and paragraph 206 of the reply. And Karadžić is right that there's no record of him using the word Zvornik in this coded conversation. But this does not mean that the trial chamber acted unreasonably in concluding that this is what he meant when he said somewhere else. It's clear from Derenich's response that Derenić understood the instruction. He says, understood. And just a few hours later, Derenić explains to others that Karadžić ordered the prisoners to be taken to Zvornik. And it's clear from the rest of the evidence that the defense is ignoring, that in this intercept, Karadžić was instructing Derenić to move the prisoners to Zvornik to be executed. Most importantly, Your Honors, this is what happened. The chamber found that at the time of the intercepted call, Karadžić already knew about the plan to kill the Bosnian Muslim prisoners. And rather than intervene to prevent the killings at that point, Karadžić ordered them to be transferred elsewhere. Paragraph 5818. And around the same time as this call, Mladic's order to transfer a large number of Bosnian Muslim detainees from Bratunac to Zvornik was conveyed down the military chain of command. Paragraphs 5711, 5309 to 5310. And during the night of the 13th of July, in accordance with Karadžić's instruction, the busing of the prisoners to Zvornik began. And over the course of the next few days, vast numbers of military and police and civilian authorities, all under Karadžić's control, worked hand in hand to move the thousands of Bosnian Muslim prisoners to Zvornik, to then systematically execute them, and then to bury them in mass graves. All while Karadžić was maintaining constant oversight through many reporting channels, and all while Karadžić was seeking and receiving information from multiple sources up and down the hierarchy. Your Honors, recall that Karadžić's order to Derenić in the intercept was to move the prisoners before 12 tomorrow. Karadžić met Derenić in person just 40 minutes after that noon deadline. And they discussed the implementation of Karadžić's order to move the rest of the prisoners to Zvornik. And they discussed the massacre of around 1,000 Muslim prisoners at Kravica warehouse the day before. And of course, Derenić had just spent the previous night working with the military to obtain the civilian resources needed for the mass burial of the Kravica's many victims, hundreds of victims. And what was Karadžić's response? When he knows not just of a plan, but that his subordinates were actively murdering Bosnian Muslim prisoners on a mass scale. And the prisoners were being transported to Zvornik, where there was no prison, no reason to send them other than to kill them. He was the supreme commander. Did he order his military to stop the killings? No. Did he order the police to stop? No. Did he explain to Derenić that this was all a terrible misunderstanding of his coded message? No. Did he order Darnage to move the prisoners to safety or to stop using civilian resources in the criminal killing operation? No, he did not. He did the opposite. As I've just described, Karadžić facilitated their work. You'll recall that later the same day, the 14th of July, Karadžić put even more power into Darnich's hands by declaring war and by appointing Darnich as president of the war presidency. Your Honors, the Chamber had every reason to conclude that Karadžić instructed Darnich that the Bosnian Muslim prisoners should be sent to Zvornik. And this was not the only evidence that Karadžić ordered the prisoners to be moved to Zvornik. The Chamber also received independent evidence from Momir Nikolić that Karadžić had ordered the prisoners to be transferred to Zvornik. Momir Nikolić was the Chief of Security and Intelligence of the Bratunac Brigade. He testified that in the early hours of the morning of 14th July, he overheard a conversation between Biara, who's Mladic's subordinate in the VRS main staff, and Vasic, the Zvornik police chief, and Darnich. The three men representing the VRS, the police, and the civilian authorities were discussing where the prisoners should be taken for execution. Not whether they should be killed, but where they should be killed. And Darnich prevailed by invoking Karadžić's instruction that the prisoners be transferred to Zvornik. The Chamber was alert to witness Nikolić's role in the crimes and treated his evidence with, quote, the utmost caution. Paragraph 5056. And it provided a robust explanation spanning 22 paragraphs and 6 substantive footnotes devoted to Momir Nikolić's credibility and reliability. And in particular, I would direct your honors to footnote 18022, where the trial chamber acknowledged Karadžić's challenges to Nikolić's evidence about this particular meeting. And the chamber was, quote, nevertheless satisfied of the truthfulness and reliability of Nikolić's account of the meeting. Karadžić repeatedly complains that Nikolić's evidence was uncorroborated. Legally, of course, this doesn't matter. There's no error in relying on an uncorroborated witness. And factually, he's wrong. Nikolić's account of this meeting was corroborated. For example, it was corroborated by The Intercept, which records Karadžić instructing Darnich to move the prisoners. The defense ignores that these two independent pieces of evidence fit seamlessly together. Nikolić's evidence was corroborated by the fact that the prisoners were actually taken to Zvornik, where they were then killed. And it was corroborated by an independent account of Mladic's subordinate Biara instructing VRS officers and municipal authorities on the 14th of July that the VRS had to get rid of the detainees in Zvornik based on an order from the, quote, two presidents. And I note here, because it's an issue raised in reply, that the prosecution has stated that Biara meant, by two presidents, Biara meant President Karadžić and likely the president of the RS Assembly, Krajišnik. And that's in the prosecution's final trial brief, footnote 3583. And as we've set out in our response brief, Nikolić's account of this meeting was also corroborated by witnesses Katanich, Davidovich, and KDZ 480. The defense argued this morning that the appeals chamber has already found that Nikolić's testimony was not corroborated. In a decision on a defense motion, This chamber found that these witnesses didn't have direct knowledge about this meeting, but did not address the issue of corroboration. Corroboration doesn't require direct knowledge or exact duplication. Evidence is corroborative when it's compatible regarding the same fact or sequence of linked facts. That's Perlich Appeals Judgment, paragraph 1643. And these witnesses are compatible. They are corroborative. And finally, Your Honors, I'd like to emphasize that it does not show error in this trial judgment for the defense to point to a different trial chamber's assessment of a witness's evidence in a different case based on a different evidentiary matrix. Credibility assessments are fact and case specific, and one trial chamber is not bound by another's views. That's Popovich Appeals Judgment, paragraphs 132 and 184. Your Honors, Karadžić advances a different version of the intercept, one in which he meant for the prisoners to be sent to the ICRC monitored prison in Batković for war crime screening. His version cannot be reconciled with the rest of the evidence about his knowledge and conduct. His alternative version would have required a large-scale conspiracy involving all of his varied subordinates and sources of information from the military, the police, and the civilian authorities up and down the hierarchy. They would all have to have been keeping a massive secret from their leader while all constantly feeding him the same lie. A conspiracy theory that the chamber rejected as, quote, inconceivable, end quote, at paragraph 5802. And Karadžić's version of the intercept is contradicted. It's contradicted by the fact that during the major executions, the mass executions from the 13th to the 16th of July, not a single Muslim prisoner was sent to Batković, paragraph 5131. And it's contradicted by the fact that despite the number of international inquiries about the prisoners from the ICRC, the UN, and journalists, Karadžić never told anyone that the prisoners had been sent to Batković. Instead, he ignored or misdirected them. Such evasions make no sense if, as he claims, he had innocently sent the Muslim prisoners to ICRC-monitored detention facilities. Your Honors, Karadžić's conviction was not based on a single intercept, nor was it based on a single intercept interpreted in light of an uncorroborated accomplice witness. Karadžić's conviction for the Srebrenica killings was based on a careful assessment of the totality of a large body of compelling evidence. And the evidence showed that Karadžić, sitting at the apex of power, used the forces under his authority and control to execute more than 5,115 Bosnian Muslim men and boys. His intent has been unequivocally established. Karadžić shows no error, and ground 40 should be dismissed. And unless your honors have any questions, I will turn the podium over to Ms. Goy to address Sarajevo.
Ms. Goy, what other topics will you cover after Sarajevo, just to give us an orientation?
Just Sarajevo, Your Honors.
Just Sarajevo.
Yeah, for the rest we are relying on our written submissions, unless obviously Your Honors have questions.
Thank you. Well, we will ask our colleagues whether they have questions.
Thank you.
Ms. Goy, you may start.
Thank you. Before addressing the individual grounds in relation to Sarajevo, Your Honours, let me briefly summarize the events in Sarajevo as found by the trial chamber, because this provides the relevant context for the individual grounds. For almost 3.5 years, from late May 92 to October 95, the Bosnian Serb forces, in the form of the Sarajevo Romania Corps, the SRK, carried out a campaign of shelling and sniping of civilians in Sarajevo, with the primary purpose to spread terror. The SRK opened deliberate fire, directed it at civilians, including children and civilian objects. Nowhere was safe for the citizens of Sarajevo. The SRK targeted civilians when collecting water, in trams, and at their homes. Towards the end of the conflict, the SRK even used modified air bombs on the city, highly destructive weapons that were clearly unsuited for the use in urban areas because they could not be directed at a specific object. Karadžić argued this morning that only a small number of people were affected in Sarajevo. But the number of civilian victims was high. Thousands were wounded or killed due to shelling or sniping. The chamber noted evidence that over 10,000 civilians were killed or wounded in Sarajevo in the indictment period. Trial judgment 4644 and 4591. But what was the reason for this campaign of terror in Sarajevo? Sarajevo, the capital of Bosnia and Herzegovina, was of extreme importance for the Bosnian Serb leadership and Karadžić in particular. Your Honours have already heard that the division of Sarajevo was one of the 6 strategic goals, and the campaign furthered and maintained this division. Karadžić and others also used the situation in Sarajevo as a bargaining chip to pressure the Bosnian Muslims and the international community into accepting Bosnian Serb demands, paragraphs 4575 and 4707. And Your Honours will hear more about how Karadžić modulated the campaign to suit his political goals. This, in brief, is the situation as found by the chamber. Your Honours heard the argument today that it was the Muslims that targeted their own civilian population. To the extent the defense is making the general argument that the Muslims were responsible for the shelling and sniping in Sarajevo, this falls outside the scope of the appeal. But in any event, the trial chamber addressed this argument in paragraphs 4503 to 4519. In particular, it noted the evidence of Richard Mole and General Rose, 2 of the witnesses that Mr. Karadžić has referred to this morning. And I refer Your Honours to the trial judgment paragraph 4512 and 4513. And the chamber accepted that there was evidence of some incidents where Bosnian Muslims targeted their own population, usually near the presidency building and for political purposes. But this was limited to a minuscule number, paragraph 4516. And the chamber addressed Karadžić's specific argument in relation to the scheduled incident he challenges, scheduled incident G8, in specific terms in paragraphs 4237, 4242, and 4250. Your Honours have also heard the defense argue that the ABIH provoked responses by the SRK. This argument relates to some extent to ground 33, the ground relating to the proper application of international humanitarian law. The trial chamber did address ABIH firing practices and acknowledged evidence that the ABIH at times were provoking SRK fire, paragraph 36 4026 and 4002 to 4003. But what matters for Karadžić's criminal responsibility is not whether the ABAH provoked SRK fire, but whether the SRK's response was in compliance with international humanitarian law. And the Chamber reasonably found that it was not. The SRK either directly targeted civilians, or the Chamber reasonably inferred from the indiscriminate or disproportionate nature of the attack that it was in fact directed against the civilian population. I would now like to address the remaining Sarajevo grounds, 36, 37 and ground 34. And with your honest permission, I'd like to start responding with the more general ground, 36, 37, that relates to Karadžić's sharing of the common purpose. The Chamber concluded that Karadžić shared the common purpose to spread terror among the civilian population of Sarajevo through a campaign of shelling and sniping. He shared it with VRS Commander Ratko Mladić, the SRK commanders Stanislav Galić and Dragomir Milosevic, and 3 other members of the Bosnian Serb presidency. The Chamber reasonably concluded in paragraph 4676 that this common plan must have come from the Bosnian Serb political and military leadership, because for over 3 years the SRK shelled and sniped at civilians in Sarajevo. For over 3 years, the shelling and sniping followed the same pattern. For over 3 years, this pattern continued in a city that was of extreme importance to the Bosnian Serb leadership. For over 3 years, the VRS main staff under Mladić and the SRK command under Galić and Dragomir Milosevic controlled the SRK. And during the entire period, Karadžić controlled the Bosnian Serb military. Karadžić's conduct throughout clearly shows that he shared the common purpose of the Sarajevo JCE and that he intended to spread terror among the civilian population through the campaign of shelling and sniping. Paragraph 4891. Karadžić continuously supported Mladić, although he knew from the outset what Mladić was planning for Sarajevo. Karadžić was directly involved in military matters in and around Sarajevo. Karadžić was aware of the attacks on civilians in Sarajevo, but denied and deflected SRK responsibility before the international community. Karadžić modulated the campaign according to his political goals. For example, he increased the level of sniping and shelling to influence negotiations with the UN and the Bosnian Muslims, to pressure them into accepting his demands. Paragraph 4886. Karadžić supported and promoted SRK commanders, although he was aware of their involvement in the campaign. And Karadžić failed to prevent the shelling and sniping of civilians and punish those responsible. In addition, Karadžić made many statements that show that he adopted a hardline position. He threatened and encouraged violence on many occasions. Paragraph 4922. The defense raises a number of challenges in relation to the common purpose and Karadžić sharing it. Today, I will just respond to 2 and thereby focus on arguments raised in reply. 1. The Chamber's finding on the common purpose stands, regardless of a meeting between Mladić, Karadžić and others prior to scheduled incident G1. And 2, Karadžić's orders purporting to protect the civilian population do not undermine the finding that he shared the common purpose. The Chamber's findings on the common purpose do not depend on a meeting between Mladić, Karadžić and others prior to scheduled incident G1. We have explained in our response brief that even if Karadžić did travel to Lisbon on 20 May, the meeting could still have occurred on that day. And this does not contradict the prosecution's position at trial as suggested in the reply brief. In the final trial brief, the prosecution referred to the meeting occurring days later than 19 May, and this does not exclude the 20th. But in any event, the conclusion that there was a common purpose to terrorize the population in Sarajevo, which Karadžić shared, does not depend on this meeting. The trial chamber found that the common purpose, quote, materialized in late May 92 with the events described in relation to scheduled incident G1, end quote. That's paragraph 4649. The meeting forms part of these events, but there are other events surrounding G1 which show that the plan materialized in the sense that it was put into action. About 2 weeks before G1, on 12 May 92, in Karadžić's presence, Mladić outlined his plan for Sarajevo in the 16th session of the Bosnian Serb Assembly. He made his view clear. Besieging and targeting Sarajevo with large numbers of heavy weapons would compel Bosnian Muslims to agree to Bosnian Serb demands. Having heard Mladić's clear explanation of his strategy for Sarajevo, the Bosnian Serb leadership voted in favor of Mladić's appointment as commander of the VRS main staff, paragraph 4735, and Karadžić, who had sought out Mladić for this post, continued to support him. About 2 weeks later then, on 28-29 May, Mladić followed through with the strategy he had announced. The SRK massively bombarded the entire city of Sarajevo, scheduled incident G1. Mladić personally issued orders to fire at areas of Sarajevo because there was not much Serb population there. He ordered to continue firing, quote, so that they cannot sleep, that we roll out their mines, end quote, paragraph 4028. On 30 May then, while the bombardment continued, UNPROFOR General Morion and Major General Mackenzie met with Karadžić to discuss the massive bombardment. And how did Karadžić react? He kept supporting Mladić and defended him before the international community. He said that due to their inexperience, the forces overreacted to attacks by the ABIH, and that Mladić did not have all the forces under his command. This was clearly disingenuous. Mladić was carrying out what he had told Karadžić and others in the assembly session 2 weeks earlier. In this conversation, Karadžić also agreed to contact Mladić in order to stop the bombardment, paragraph 4037. But not even a week later, on the evening of 5 June 92, the SRK launched another attack against the entire city of Sarajevo that lasted 3 days and killed or injured numerous civilians and damaged and destroyed civilian buildings. Scheduled incident G2, paragraph 4055. Therefore, based on the events around G1, the chamber reasonably concluded that a common purpose had materialized to spread terror among the civilian population through the campaign of shelling and sniping, and that Karadžić shared that purpose. This holds true regardless of when or whether the meeting occurred. This brings me to the second point. The chamber discussed Karadžić's few orders that civilians were not to be targeted and concluded that they did not undermine his shared intent. This was reasonable because these orders happened when Karadžić was pressured by the international community, under threat of NATO airstrikes, or when it was in his interest to do so to achieve his political goals. These orders were not meant to stop the campaign of shelling and sniping altogether. At most, They were meant to stop it for a certain period when the campaign was inconvenient for Karadžić, paragraph 4926. On other occasions, 4927. On other occasions, Karadžić was paying mere lip service to the protection of civilians in Sarajevo, paragraph 4936. The defense argues in reply that Karadžić's orders to protect the civilian population were effective, regardless of whether they were issued following international pressure. But this misses the point. These orders were effective as long as this was convenient for Karadžić. As soon as this reason fell away, the campaign continued. For instance, 2 days after the first Makale incident of 5 February 94, that Your Honours will hear more about in a bit, Karadžić issued an order directly to the SRK commanders and units where he threatened to hold them personally responsible for any attacks on civilians. Trial Judgment 4776. And this order was effective, as the Chamber found in the same paragraph. And why did Karadžić issue this order? Because of the outrage and pressure by the international community after the shelling of Makale market. As the Chamber found, the Bosnian Serbs faced the possibility of NATO airstrikes. Paragraph 4877 and footnote 16631. But when the political pressure decreased, the campaign continued. Footnote 16626. This shows Karadžić could stop the targeting of civilians when he wanted to. That the campaign of targeting civilians in Sarajevo continued for over 3 years means that he, the Supreme Commander, intended it to continue. Karadžić's general instruction to the protection of the civilian population in Sarajevo were on most occasions mere lip service. The Chamber reasoned that this was clear to all present, given that instructions of the Supreme Commander, had no effect on the ground. Paragraph 4936. For example, in reply, the defense points to the language of Directive 1, that maltreating the civilian unarmed population is strictly forbidden. Exhibit D 232. This general language was mere lip service. It had no effect in besieged Sarajevo. Mladić issued Directive 1 on 6 June 92, in the midst of the second massive shelling incident in Sarajevo, G2. Despite this general language, the massive bombardment of the entire city of Sarajevo continued. If Karadžić had really wanted to stop the bombardment of the civilian areas in Sarajevo through this directive, he would have made this clear, like he did after the first Makale incident. There he said, quote, exclude any possibility of uncontrolled shelling. Keep the behavior under control and sanction offenses, end quote. Exhibit P46. In contrast, 846, I'm sorry. In contrast, Directive 1 does not mention the shelling of Sarajevo, nor any sanctions. In sum, Your Honours, the Chamber's conclusion that Karadžić shared the common purpose to spread terror among the civilian population is reasonable. It is amply supported by the evidence. Not only did the Supreme Commander not stop the campaign that was going on for over 3 years, or hold perpetrators accountable, no. He supported and promoted those in charge and modulated the campaign to achieve his political goals. Grounds 36 and 37 should be dismissed. I would like to end my submissions with ground 34, the shelling of Makale market on 5 February 94. The Chamber found that the SRK fired the 120mm shell that hit Makale market on 5 February 94 in the middle of the day. Makale market was an open-air market where the citizens of Sarajevo bought and sold food and other goods. It's located in the old town of Sarajevo, a part of Sarajevo which the SRK frequently fired at. Also on 5 February, many civilians were at Makale Market. And when the shell exploded, it killed at least 67 and injured more than 140. Many were women and elderly. Jonas, the conclusion that the SRK fired the shell is reasonable. The defense today raised concerns, pointing to a UN report and said that the chamber relied on a Muslim official who said he was going to prove that it was the Serbs. The defense is talking about Dr. Berkozevic, who estimated the angle of descent on which the chamber relied. And the chamber was reasonable to rely on Dr. Berkozevic's estimate. And the angle of descent is relevant because it helps to determine the origin of fire. But there are also other factors the chamber took into account to reach its conclusion that the SRK was responsible for the attack. To show that the trial chamber's conclusion was reasonable, I will explain the relevance briefly of the angle of descent. I will then address why the chamber was reasonable to take into account Zečević's angle. And lastly, I'll point to the other factors that the chamber took into account to reasonably determine that the SRK fired the shell. The angle of descent is relevant because it can be used to determine whether the shell was fired from the SRK-held territory. It's not in dispute that the shell was fired from north-northeasterly direction, 18 degrees east from north. And to make this more visible for your honors, we're using a map on which witness Zečević had marked the direction of fire. And that's exhibit P2317, page 17 in the BCS version. And for ease of visibility, we have highlighted Zečević's markings of the direction of fire. And your honors can see the direction of fire between the two outer red lines. The confrontation line was 2,300 to 2,800 meters away, trial judgment 4199. And we've added the confrontation line from exhibit P1058 onto Zečević's map. And the SRK controlled the territory outside the red confrontation line, so to the northeasterly direction. Therefore, if the shell was fired from a distance greater than the distance to the red confrontation line, it must have come from the SRK. And this distance, and I'm getting a bit technical now, is essentially determined by two factors. The angle of descent of the shell, how steep it enters into the ground, how steep the flying curve is. The lower the angle, the further the distance to the impact, and the number of charges used. A charge is an additional propellant which adds to the speed and therefore to the distance. Up to 6 additional propellants or charges can be added to the mortar shell. So when one then puts the angle of descent and the number of charges into a firing table for this type of mortar, one can determine how far they fly. As for the charges, it's not in dispute on appeal that the shell was fired with 3 or more charges. Trial judgment 4248. And as for the angle of descent, the chamber relied on the angle estimated by Zečević, 55 to 65 degrees. And at this angle and charge 3 or more, the source of fire is well within SRK-held territory. And Zečević visualized this on his map. He marked the possible areas of origin of fire for the different charges, and we have highlighted those areas in blue. And we can delete charges 1 or 2 because it's not in dispute on appeal that the shell was fired with at least 3 charges. Then becomes clear that at this angle of descent, 55 to 65 degrees, the origin of fire is well within SRK-held territory. So the angle of descent can be calculated based on an analysis of the crater left by the shell, which brings me to the second point.
You have 5 minutes, Ms. Gray.
5? I'm sorry, Your Honor, I thought I had still 15 minutes.
Oh, sorry. Oh, my. I apologize.
Thank you. I'm very relieved. So the chamber was reasonable to rely on the angle of descent of 55 to 65 degrees as estimated by Zacevic. And this was reasonable because those experienced with crater analysis confirmed that the crater was sufficiently intact to make reliable estimates, and that the range estimated by Zacevic overlapped to a large extent with the estimates made by others. The tail fin of the shell was removed on the day of the incident. But despite this removal, the crater remained sufficiently intact to make reliable estimates of the angle of descent. The chamber considered defense arguments that the measurements and estimates were unreliable because the crater had been disturbed, and it reasonably concluded that the angle of descent could at least be estimated, relying on Zacevic and Hamel. So Zacevic analyzed the crater the day after the incident, on the 6th of February. He had the required expertise. He was a mechanical engineer with years of experience in the weapons industry, footnote 14231. And the chamber explicitly addressed defense arguments that Zacevic is not credible and dismissed them as unfounded, paragraph 4247. Zacevic explained in detail how he measured the angle. He placed the stabilizer back into the tunnel created by the penetration. Transcript page 12168. And Zacevic confirmed that when he placed the stabilizer back into the tunnel, he positioned it in a way it should have been positioned, and that there was no major deviation from its original position. Transcript page 12168. Alsop, the defense's own expert, looked at footage of the original position of the stabilizer and footage when the stabilizer was reinserted. And he confirmed that Zacevic seemed to insert the stabilizer in a position similar to its original position. Transcript page 29461. And Your Honors can see how it looked when the stabilizer was inserted back into the crater on 6 February 94. This is a still from the video exhibit D896 at 39 minutes 15 seconds. And I also refer Your Honors to the matching photograph exhibit P5951, page 1. And Your Honors can see the stabilizer fits tightly in the hole. And Your Honors will also have noticed that this hole bears no similarities with the defense's drawing in paragraph 183 of the reply brief. Zacevic calculated an angle of approximately 60 degrees and added a margin of error of 5 degrees on either side, and therefore estimated 55 to 65 degrees. Importantly, Your Honors, defense expert Alsop acknowledged that Zacevic's margin of 10 degrees is a generous margin. Transcript page 29508. And just to put this in perspective for Your Honors, 10 degrees is generous because it covers almost 1/3 of all theoretically possible ranges. The theoretical possible range was only 36 degrees. This is because the angle had to be higher than 49 degrees to clear the buildings around the market, and it could not be higher than 85 degrees, which is the maximum possible angle. And I refer Your Honors to Trial Judgment 4246, Alsop at transcript 29508, and exhibit P5922, page 5. The chamber was therefore reasonable when it relied on Zacevic's ability to estimate the angle on the 6th of February. But not only Zacevic on the 6th, also Commandant Hamel and Major Khan estimated the angles even on the 11th of February. Hamel had the required expertise. He was a technical advisor to the UN investigation team. and had extensive knowledge of artillery weapons. Footnote 14231. Hamel explained that on 11 February the crater was not completely intact, but intact enough to estimate an angle of descent. Exhibit P 1994, E-Court page 137. Also, his fellow commission member Khan acknowledged that while the exact tunnel could not be ascertained, he could work out an approximate angle. Exhibit P 1441, page 23. And why then, as Karadžić has raised this morning, did the UN report conclude that the angle could not be reliably estimated? The Chamber does not answer this question directly. But this does not undermine the Chamber's reasoning. It was reasonable for the Chamber to rely on the evidence of those experienced with crater analysis, Zečević and Hamel, in light of their explanation as to the state of the crater when they conducted their analysis. Moreover, the Chamber was reasonable to rely on Zečević because the angles of descent estimated by Hamel and Khan independently overlap to a very large extent with Zečević's estimate. And Zečević had the largest margin of error. Your Honours, the original estimates of Hamel and Khan were made in a different measuring unit, mils, and converted by the Chamber, and in the case of Khan, by the OTP to degrees. And Your Honours can find the conversion formula at transcript page 28944. And I note that in the original mils, Khan and Hamel estimate the same highest range. Your Honours can find this, Exhibit P 1441, page 17. The Chamber was mindful that there were also measurements or estimates by others with different angles of descent. It addressed those differences and reasonably explained why the other estimates could not be relied upon. Paragraph 4246 and 4247. What remains are crater analysis by experts who each explained why and how they were able to estimate the angle of descent, and then independently came up with a very similar estimates. Between the three, the Chamber reasonably relied on Zečević, who had the broadest margin of error, a margin which even defense expert also acknowledged was generous. Your Honours, the defense makes a new suggestion in reply. Namely, that the estimates overlap because they all analyzed the crater which had been altered. This new suggestion is not supported by the evidence. Hamel, in fact, made a careful distinction between a crater which is sufficiently intact to still allow an estimate of the angle of descent, and a crater that is so disturbed that no measurements are possible. He said the crater was disturbed between his first analysis on 11 February and his second analysis on 12 February 94, which made measurements impossible on the 12th. That's Exhibit P 1441, page 25. The defense's new theory is also contradicted by another piece of technical evidence, the shrapnel pattern. Shrapnel pattern are the imprints left by the shrapnel on the surface when the shell explodes. They are not influenced by the disturbance of the crater. Zečević concluded in his report that the shrapnel pattern was typical for an angle of descent of 60 degrees. Exhibit P 2317, page 5. This rebuts the defense's new theory, and it further confirms Zečević's estimate of the angle of between 55 and 65 degrees based on the crater analysis. In addition, the Chamber reasonably concluded that the defense fired the shell by also relying on other non-technical evidence. This brings me to my third point. The chamber took into account other evidence, non-technical evidence, which also indicated that the shell came from the SRK side of the confrontation line, and more particularly, SRK positions in Merkovici, trial judgment paragraphs 4249 and 4250, namely, that the SRK had 120 millimeter mortars in the area of Merkovici, which is north-northeast of Makale, in the established direction of fire. That the SRK opened fire on the Old Town from positions along the direction of fire. The chamber referred to evidence that in 1993, the artillery regiment in Merkovici had fired 30,000 to 40,000 rounds into the city. Trial judgment 4250, 4192. And just the night before the incident, the SRK had shelled the city center. Footnote 14243. The shelling of Makale thus fit neatly in the pattern of SRK shelling. The chamber further considered and reasonably dismissed the possibility of the ABIH shelling Makale. The chamber noted that there was no evidence that the ABIH had mortars in the area of Gordogne, which it held in the established direction of fire, and that there was no sighting of mobile mortars on that day or shell noise coming from within the city. And in any event, achieving an accurate hit on Makale market from a mobile mortar would be extremely difficult, bordering on impossible. Thus, in sum, the defense failed to show that the trial chamber was unreasonable when it concluded that the SRK fired the shell that hit Makale market on 5 February 94. Ground 34 should be dismissed. It was just pointed out to me that I said the defense fired the shell, of course, that the SRK fired the shell. I apologize.
I was just about to ask you about it.
That I misspoke. I apologize, Your Honors. To conclude, Your Honors, the prosecution, in the prosecution's view, the chamber properly found Karadžić guilty of egregious crimes across 4 joint criminal enterprises. He received a fair trial and fails to demonstrate any factual or legal errors in the judgment. His appeal should be dismissed. This ends our submission except for a small housekeeping matter. At transcript page 120, the reference to the Perlich appeal judgment paragraph should actually be the reference to paragraph 1647. Unless Your Honors have any questions.
Let me look into that. Any questions? Judge Sekula, Judge Johnson, Judge Gatti? No? Thank you very much for your argument. I thank Mr. Robinson and Mr. Karadžić for his arguments, and this will be, sorry?
What about Ms. Gibson?
And Ms. Gibson, of course, particularly Ms. Gibson. We will, I believe this is the end of the day, and tomorrow, let me remind you of the schedule. We will start exactly at 9:30, and until 11 a.m. we will have a reply of Karadžić. 11 till 11:30 a pause. Appeal of the prosecution 11:30 till 12. 12 till 12:30 response of Karadžić. 12:30 to 12:45 reply of the prosecution. And then Mr. Karadžić would have, should he desire, an opportunity for a personal address of 10 minutes. So on this we will rise now, and I thank you again.
All rise. We will have it.